Epstein files are here. On November 19th, Congress passed the Epstein Files Transparency Act, ordering the Justice Department to release all the information it has on the notorious sexual predator within 30 days. Finally, after years of waiting, we will learn the truth. Who participated in Epstein's years of abuse of young girls and women? What was the source of his huge wealth? Who enabled this behavior? Who helped cover it up? And how did he get away with it for so many years? Or maybe we won't. The Justice Department seems to be in no particular hurry to get out anything other than photos of Bill Clinton. So far, they've released less than 1% of the documents in the government's possession, and most of that was already in the public record. So what can anyone do about this? On the campaign trail, Trump said he was absolutely going to release the Epstein files.
Would you declassify the Epstein files?
Yeah, I would.
In February, Attorney General Bondi said the files were on her desk, just waiting to be released at the president's directive.
The DOJ may be releasing the list of Jeffrey Epstein's clients? Will that really happen?
It's sitting on my desk right now to review.
She even invited a bunch of MAGA influencers to the White House and handed them binders labeled The Epstein Files Phase 1. And then she put out a press release congratulating herself for being so brave and honest and following through on President Trump's commitment to transparency and lifting the veil on the disgusting actions of Jeffrey Epstein and his co-conspirators. FBI Director Kash Patel vowed that there will be no cover-ups, no missing documents, and no stone left unturned. If there are gaps, we will find them. If the records have been hidden, we will uncover them, and we will bring everything we find to the DOJ to be fully assessed and transparently disseminated to the American people. In reality, the binders contained virtually nothing that wasn't already in the public record. In March, Bondi went on Fox and promised Sean Hannity that the Trump administration would publish it all. She claimed that there were truckloads of data and said heads would roll when she found out who'd been hiding it from her.
Why were they sitting in the Southern District of New York? I want a full report on that. You know, sadly, these people don't believe in transparency, but I think more, unfortunately, I think a lot of them don't believe in honesty. And it's a new day, it's a new administration, and everything's going to come out to the public. The public has a right to know. Americans have a right to know.
But then in July, Bondi put out another memo saying that the Epstein files were so full of child sex abuse material that it is the determination of the Department of Justice and the Federal Bureau of Investigation that no further disclosure would be appropriate or warranted. The client list, which was supposedly on her desk in February, didn't exist. There was no proof that Epstein had blackmailed anyone, and no one else would be charged. The blowback from Trump supporters who'd been screaming for years about a cover-up was fierce. And it didn't help that there were reports of FBI agents spending thousands of man-hours poring over the files and being instructed to redact any mention of Trump's name.
I don't understand why the Jeffrey Epstein case would be of interest to anybody. It's pretty boring stuff. It's sordid, but it's boring. And I don't understand why it keeps going.
And the president wasn't making himself look less guilty. He even filed that bonkers lawsuit against Rupert Murdoch and the Wall Street Journal over a report that he drew boobs on a birthday card to Epstein in 2003. He wants $10 billion for that one. Trump ordered Attorney General Bondi to investigate Jeffrey Epstein's involvement and relationship with a bunch of prominent Democrats, including Bill Clinton and Larry Summers. This is another Russia scam with all arrows pointing to the Democrats, and Bondi jumped right on it despite having said in February that no one else would be charged. Note that she parked that very serious investigation at the Southern District of New York, the place she just accused of hiding the Epstein documents from her because they were so dishonest. Then Trump yelled on social media about the Jeffrey Epstein hoax, which my past supporters have bought into hook, line, and sinker. Among those past supporters was Marjorie Taylor Greene, who recently became a past member of Congress. Along with her fellow Republican representatives Thomas Massie, Lauren Boebert, and Nancy Mace, Greene joined every House Democrat in an effort to force Speaker Mike Johnson to allow a vote on the Epstein Files Transparency Act. Johnson did everything he could to delay that vote. Check out our video on his months of shenanigans. Then, in November, after Arizona Representative Adelita Grijalva was sworn in and became the 218th signature on the discharge petition, he finally ran out of road, at which point the entire Republican caucus decided that they'd always been for it, and the law passed 427-1 in the House and 100-0 in the Senate. Seeing the writing on the wall, Trump signed the bill into law on November 19th. at which point the Justice Department had a month to hand over all the Epstein documents. The law says not later than 30 days after the date of enactment of this act, the Attorney General shall, subject to a narrow set of exceptions, make publicly available in a searchable and downloadable format all unclassified records, documents, communications, and investigative materials in the possession of the Department of Justice. But of course, we wouldn't be making this video if that's what had happened, would we? I'm assuming that you are not someone who needs to hide evidence of hideous crimes, but that doesn't mean that online privacy isn't a priority for you. And so now is probably a good time to wipe all your personal and private information off the internet. Your cell phone number, home address, email address, private social media accounts, and tons of sensitive data are shockingly easy to purchase by anybody online. But malicious actors cannot hurt you if they can't find you. And so you can fight back and take control of your private information by signing up for today's sponsor, Incogni. Incogni wipes your personal data from the internet by searching the internet, reaching out to data brokers and websites directly on your behalf, and forcing them to remove your private information. If they resist, Incogni will take care of that too, because Incogni fights back. But what makes Incogni truly powerful in taking back control of your privacy is the custom removals feature. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. I've been using Incogni for a while now. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning that the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me. I could never do this myself, so thanks to Incogni for weeks of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you scan the code on screen or click on the link in the description, you'll get 60% off their annual unlimited plan, or try Incogni risk-free for 30 days. If you decide you want to keep it, you'll still get the 60% discount so long as you use our code LegalEagle, all one word. So sign up for Incogni or we will see you in court. The Justice Department did start publishing the Epstein evidence on December 19th. Lots of it looks like this, just inchoate photographs documenting the chain of custody of evidence. What's in those files? Well, I don't know. A lot of what was immediately released was already in the public record, like Epstein's address book. The first document dump also included thousands of pages of court records, which are publicly available online and have been for years. The DOJ immediately pushed out transcripts and audio of Deputy Attorney General Todd Blanche's jailhouse interview with Epstein's accomplice Ghislaine Maxwell, where she said how much she admires President Trump, and she pinky swore that she never saw him do anything inappropriate ever. This is somewhat undercut by emails where Epstein said, "I want you to realize that dog that hasn't barked is Trump. Redacted victim spent hours at my house with him." And Maxwell said, "I have been thinking about that." In another email, Epstein told journalist Michael Wolff that, of course, he, Trump, knew about the girls as he asked Ghislaine to stop. But what motive would Ghislaine Maxwell have to lie, right? She's only serving a 20-year federal prison sentence with no way out besides a presidential pardon.
I don't know. I haven't really been following it too much. I just wish her well, frankly.
The Justice Department also made darn sure to front-load the doc dumps with images of Bill Clinton. Then White House communications staff blasted those images out like they were some kind of vindication. Trump spokeswoman Abigail Jackson tweeted, "Per the Epstein Files Transparency Act, DOJ was specifically instructed only to redact the faces of victims and/or minors. Time for the media to start asking real questions." The implication being that Bill Clinton was involved in the victimization of young girls. For the record, Clinton's spokesman called to release all photos and documents from the Epstein files, which mention the former president. But Jackson's post gets at a problem with these redactions, which is that they are both over-inclusive and under-inclusive. The Epstein Files Transparency Act allows the government to withhold personally identifying information about victims, and it allows them to withhold child sex abuse materials, usually referred to as CSAM. And that's what the government did, but not consistently. One victim, who has only been referred to in court documents as Jane Doe, told CNN that she was horrified to see her name appear multiple times in the documents released by the government. To the extent that there was anything new, it served to highlight how many times law enforcement had a chance to stop Epstein and just whiffed it. In 1996, victim Maria Farmer spoke to the FBI about child pornography in Epstein's possession. Nothing came of it. In 1997, model Alicia Arden told police Epstein groped her in a hotel room during what was supposed to be a job interview. Police shrugged it off. In 2001, women recruited to work for Ghislaine Maxwell told police that men were dropping off young girls at Epstein's house in Palm Beach. In 2004, a cab driver flagged down a cop and said that he dropped off teenage girls at Epstein's house and overheard them talking about being paid for sex. Throughout 2005 and 2006, police interviewed dozens of girls and women who said they'd been abused by Epstein and Maxwell. It is clear that law enforcement did take this seriously. But Epstein had powerful friends, and in 2008 he got a cushy plea deal that allowed him to essentially sleep at the jail for a few months and then be on his way. It wasn't until 2019, when journalist Julie Brown of the Miami Herald released her blockbuster story on Epstein, that authorities finally decided to do something about a man who'd been abusing girls more or less publicly for 30 years. None of that is new information, but seeing it all cataloged together is certainly bracing. At the same time, the DOJ redacted lots of other stuff that appears to fall far outside the scope of the law. There are hundreds of pages of documents that are just blacked out in their entirety, and some stuff is just weird. PBS reports that some previously published photos just disappeared from the database, like a painting of a nude woman and an image of a credenza with framed photographs, including one of Donald Trump, which was taken down, and then the photo came back after people noticed the stealth deletion. Now, we at LegalEagle are not generally given to conspiracy theories, but we will note that many members of the current Trump administration, including FBI Director Kash Patel, spent years demanding the release of the Epstein files. They implied that the government was part of a massive cover-up to protect the powerful, and now they are the government, and they've changed their tune. Also, we can't help but notice that the government is making a whole lot of very crazy news since they missed that deadline to comply. And we're not saying it's part of a cover-up, but we are saying that if the shoe was on the other foot, MAGA world would be screaming it from the rooftops. But what's most notable here isn't what disappeared from the DOJ's list of Epstein files, it's what was never there at all. The Epstein Files Transparency Act requires the release of broad categories of records, including financial records, and all internal prosecutorial documents from the many criminal investigations. As of this recording, that is nowhere near complete. There are some records from JP Morgan's deliberations regarding the cost and benefits of keeping Epstein as a client after it became clear that he was a serial child sex abuser. But in the main, if you want to know how Epstein made so much money, you are out of luck. And by sheer coincidence, or maybe not, that omission also shields the very powerful men who entrusted him with their assets. Notably, Les Wexner, the founder of companies like The Limited, Bath & Body Works, and Victoria's Secret, and Leon Black, the former CEO of the private equity firm Apollo Global Management. And by the way, it's not just us saying that. It's the guys at JP Morgan who were still doing business with Epstein in 2013 after he'd served his slap-on-the-wrist sentence in Florida for soliciting a minor for prostitution. The House Oversight Committee says that it will be issuing subpoenas for Wexner and the executors of Epstein's estate, so stay tuned for that. The DOJ disclosed a huge number of documents from those Florida law enforcement investigations in the early 2000s, including some absolutely heart-wrenching recorded interviews with young girls he abused. But almost nothing other than public court documents has been posted from the 2019 case against Epstein for sex trafficking. So if you want to see his lawyers entering their appearance on the docket, DOJ's got the hookup, or a transcript of the scheduling conference that's been available on the federal court website for 6 years. Knock yourself out. But if you want to know whether they ever discussed charging anyone else, you're out of luck, friend. Ditto if you have questions about the Ghislaine Maxwell case. There are a handful of emails pointing to investigative leads that weren't followed. For instance, this email refers to 10 co-conspirators, including one who is a wealthy businessman in Ohio, and that's an obvious reference to Wexner. Another email shows prosecutors discussing the flight logs for Epstein's plane, which showed Trump was a frequent flyer, including on 2 trips with women who are characterized as witnesses in the Maxwell prosecution. What happened after they flagged that? Well, I don't know. It's presumably in the 5 million pages of documents the DOJ has yet to release. And that's just not what the Epstein Files Transparency Act says is supposed to happen. Congress ordered the DOJ to release all investigations, prosecutions, or custodial matters pertaining to both Epstein and Maxwell, the names of all individuals, including government officials, named or referenced in connection with the Epstein's criminal activities, civil settlements, immunity or plea agreements, or investigatory proceedings, and all internal DOJ communications, including emails, memos, meeting notes concerning decisions to charge, not charge, investigate, or decline to investigate Epstein or his associates. The law said the DOJ had to produce that stuff within 30 days, so by December 19th, and they just didn't. It specifies that no record shall be withheld, delayed, or redacted on the basis of embarrassment, reputational harm, or political sensitivity, including to any government official, public figure, or foreign dignitary. Finally, the law says that AG Bondi shall submit to the House and Senate within 15 days of completion of the release a report listing all categories of records released and withheld, and a summary of redactions made, including legal basis. And she didn't do that either. And even though the deadline was 3 weeks ago, the government hasn't even looked at 99% of the documents in its possession. And we know that because on January 5th, Jay Clayton, the U.S. Attorney for the Southern District of New York, filed a 4-page status report for Judge Paul Engelmeyer, the judge overseeing the Ghislaine Maxwell case. Clayton hyped the DOJ's substantial and impressive commitment to releasing the Epstein files, and he bragged that hundreds of lawyers have spent thousands of hours looking through the documents. He said they found more than 2 million that need to be produced, but so far they've turned over just 12,000, which by my math rounds to 0%. And frankly, it's less than that since a lot of what they've produced is duplicates. Obviously, the DOJ is in flagrant violation of the law. There's no provision that allows for rolling production, despite Deputy Attorney Todd Blanche sending Congress a snotty letter saying that it's settled law that you don't have to comply with statutes when it's super inconvenient. Okay, realistically, it does take time to review millions of records for CSAM and victim information, but the law doesn't have a DOJ needs more time loophole. Everything was supposed to be out by December 19th with an explanation of redactions due on January 3rd. So now what? Who can do something about this? All right, let's start with the easy question. Is this a crime? The answer to that is no. Nowhere in this law does it say, if you don't, then you'll be criminally liable. There's no penalty for missing the deadline. Okay, can you or I sue the DOJ to make it do what it's supposed to do? Again, no. There's no private right of action here, not directly. The anti-Trump legal group Democracy Forward Foundation filed a Freedom of Information Act suit against the DOJ and the FBI trying to pry loose some of these Epstein files. But the universe of documents covered by FOIA is much narrower than what the Epstein Files Transparency Act requires the DOJ to disclose, so that's not going to do it either. Okay, now we got all that out of the way, let's talk about the real options here. Representatives Ro Khanna and Thomas Massie, the main sponsors of the Epstein Files Transparency Act, are threatening to file inherent contempt charges against Bondi. Khanna calls the government's lackluster production of documents obstruction of justice and accuses the DOJ of spending more time protecting the Epstein class than the survivors. He told MS Now's Ali Velshi that they'll propose fining Bondi $5,000 to $10,000 a day for every day she's not in compliance with the statute.
Well, the inherent contempt that Massie and I will be filing would make Pam Bondi personally liable for $5,000 to $10,000 a day for every day that she does not release the files and comply.
And considering it took the DOJ more than a month to produce 1% of the documents at issue, that could be an expensive proposition. But that seems unlikely to happen for a whole lot of reasons. Inherent contempt is kind of like Halley's Comet. It's real, and maybe if you're lucky, you'll see it once in a lifetime, but don't go rushing out to look for it every time someone mentions it, or you're going to be pretty disappointed. Congress's power to hold someone in inherent contempt isn't explicit in the Constitution, but the first use of inherent contempt dates back to 1795. It would require the full House to pass a resolution after which the Sergeant-at-Arms would round up the offending party, here the Attorney General of the United States, and lock her up until she agreed to comply. In 1821, the Supreme Court blessed the process in a case called Anderson v. Dunn. But the last time Congress held anyone in inherent contempt was 1935. There is no guarantee that today's Supreme Court would uphold the Anderson precedent, but I don't think we're going to find out because there's no way you're going to get a majority of the House to go nuclear and vote to arrest the Attorney General for producing documents too slowly. Okay, next. On December 22nd, Senate Minority Leader Chuck Schumer introduced a resolution which would require his Republican counterpart, Majority Leader John Thune, to initiate or intervene in a civil lawsuit against the Justice Department to force it to comply with the Epstein Files Transparency Act. He called the delay a blatant cover-up by Pam Bondi and Todd Blanche to shield Donald Trump from accountability and demanded that Republicans show the same support for upholding the bipartisan law they passed and demand the Trump administration release all the Epstein files. So far, there's been no action on that one. Over in the House, Democratic Representatives Jamie Raskin and Brad Garcia, ranking members of the Judiciary and Oversight Committees, put out a joint statement calling generally for courts to intervene to enforce the Epstein Files Transparency Act. But courts do not make it easy for individual members of Congress to sue the government, especially when those members hail from the minority party. In a 1997 Supreme Court case called Raines v. Byrd, 6 members of Congress challenged the constitutionality of the Line Item Veto Act. That law essentially allowed the president to take a Sharpie to duly enacted legislation and say he wasn't going to treat all of it as valid. Even though that law said that any member of Congress adversely affected could sue, the court said no. Members of Congress do not have a personal stake in the laws they pass. They have an institutional interest, and so individual members lack standing to sue. That's why Senator Schumer is trying to force the Senate as a whole to file a lawsuit, because he knows that he'll get tossed out of court if he files a suit on behalf of a group of senators, even if that group is bipartisan. Incidentally, the Supreme Court did eventually strike down the Line Item Veto Act, but only after President Clinton actually used the law to zero out congressionally mandated Medicaid reimbursements, after which New York sued because it had suffered a legally cognizable injury, and the Supreme Court held the law was unconstitutional. So knowing that it's highly unlikely that either House of Congress will vote to sue the Trump administration or hold AG Bondi in contempt, Representatives Ro Khanna and Thomas Massie, the bipartisan team behind the Epstein Files Transparency Act, have gotten creative. Their long-shot ploy to rope in the courts has to do with the grand jury proceedings in the Epstein and Maxwell criminal cases, which are sealed as a matter of law. Grand jury secrecy is basically sacrosanct, which is why all 3 courts to consider the matter back in the summer refused the Justice Department's request to release the grand jury materials in the Epstein and Maxwell cases. So back in the summer, the Trump administration was still stalling public demands for information on Jeffrey Epstein. And so in July, Bondi and her deputy Todd Blanche did this sort of head fake where they said, we're demanding release of the grand jury materials. And they asked courts in New York and Florida to unseal them. That was always, if you'll pardon me saying so, bullshit. The government had mountains of evidence in its possession. It didn't need a court order to release any of it. And as Judge Richard Berman pointed out when he denied the motion, the information contained in the Epstein grand jury transcripts pales in comparison to the Epstein investigation materials in the hands of the Department of Justice, and the only witness who testified to the grand jury was an FBI agent who is still alive, and meaning that he was able to speak publicly if given permission from the agency. And as Pam Bondi knows perfectly well, extensive public interest is not a legally cognizable basis to demand to unseal grand jury materials, which is why all 3 courts told the DOJ to take a hike last summer. But then Congress forced the issue by passing the Epstein Files Transparency Act, and the DOJ went back to the courts and said, okay, how about now? Can we unseal the grand jury records now? And this time the court said yes, because they had this new law and the grand jury materials can be unsealed with appropriate redactions to protect the victim. And that's the hook that Khanna and Massie are trying to use to get a court to force the Justice Department to unseal the rest of the Epstein documents. So look, remember that letter from U.S. Attorney Jay Clayton to Judge Engelmeyer in the Southern District of New York talking about all the documents the DOJ had produced? Khanna and Massie are trying to piggyback on top of that letter by asking Judge Engelmeyer to step in and supervise the government's compliance with the Epstein Files Transparency Act. They want the judge to appoint a special master or an independent monitor to ensure that all the documents are made public immediately without inappropriate redactions. They want the court to compel testimony from the Justice Department about the production that's been made, the pending productions, and the representations that have been previously made to the court. Massie and Khanna say that Clayton made this the court's problem by bringing it up in his letter, and they worry that absent an independent process, we do not believe the DOJ will produce the records that are required by the act and what it has represented to this court. I mean, as they say, it's a bold strategy, Cotton. I don't think it's going to pay off, but props for creativity. Look, judges are extremely reluctant to step outside their lane and do things without a clear jurisdictional mandate. And that's especially true when it comes to telling other branches of government what to do. There's a big separation of powers problem. So put simply, brass tacks, Khanna and Massie are asking the court to Bigfoot in and start telling Pam Bondi how to do her job. And the court may have jurisdiction over some of that data set covered by the Epstein Files Transparency Act because that's the criminal case it's presiding over, but it's definitely not all of those documents. And I think that gets at the root of the problem here, which is that you have 2 branches of government that are functionally broken, and they're trying to get the third to pick up the slack. right? The executive branch has a job, and that job is to comply with the law, including the Epstein Files Transparency Act, which is clearly dragging its feet and releasing this stuff in dribs and drabs and doing so in a way that's designed to protect Trump and hurt his political enemies, particularly Bill Clinton. At the same time, Congress also has a job, and that's to pass laws and then oversee compliance by the executive branch. But it's not doing that. It's not using the tools that it has in its own arsenal, right? It could sue the DOJ to force compliance. It could hold Bondi in inherent contempt, but it won't because everything's broken and it doesn't work. And so now Massey, Khanna, and even Pam Bondi are like rolling into the federal courts and saying, fix it. We don't know what to do. Well, everybody knows what to do. They just don't want to use the tools that they've got. And the court can't fix that. That's a political problem, not a legal one. And the only way out of this mess is for politicians to pony up and do their damn jobs.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.